prosecution case has resumed at the High Court in Pietermaritzburg. This is the second application from former President Jacob Zuma to have State Advocate Billy Downer removed from the case. We've been hearing mainly from his legal counsel arguing his case. We heard from Advocate Thabani Masuku a little bit earlier on saying that a prosecutor ought to be trusted, not only by the accused but by the public as well, arguing that Billy Downer is emotional about this case. We speak now to Advocate Romeo Nthambeleni, who is in studio with us to help us make sense of what it is we've been hearing throughout the course of the morning. Thank you very much for your time this afternoon. So we heard from Advocate Dalimpo a little bit earlier on, arguing that the fact that Downer remains under the threat of private prosecution by the former president is enough to disqualify him from prosecuting Jacob Zuma. How should we understand this in light, or rather in relation to the SCA ruling invalidating the former president's private prosecution, and that the former president will seek to challenge that ruling?
Okay, thank you. Good afternoon, Dudu. No, you're quite correct that the Supreme Court of Appeal has made a ruling in relation to this appeal, but there's still an appeal that is pending before the Supreme Court of Appeal in relation to this matter affecting the prosecutor Billy Downer in the matter. So what we are basically hearing is what Judge Kuhn did not deal with when he had the matter first, and then he referred the matter to a different judge to be able to hear this application that is being brought again for the recusal of Billy Downer. So it's a fact that is a regurgitation of the same facts, but what is being argued differently is his constitutional rights in terms to fair trial, which was done since the morning up until now, to make sure that there's a distinction that is being made between the previous section 106(1)H and what is being argued before the court since this morning, Dudu.
Have they managed through their arguments, do you perceive, to convince the court that indeed his constitutional rights were violated?
Look, from what we are reading from the judge since in the morning, you obviously can't tell how the judge is going to decide, but they are making a compelling case that Zuma's constitutional rights are important and they need to be entertained by the court. And then what is important is that now Billy Downer, as a lead prosecutor, has compromised himself. He's no longer an independent prosecutor, so the court cannot actually ignore that fact. And they demonstrate by also looking into his evidence that has been filed in the affidavit as to what he said, and the matter that he wants to make sure that the former president is prosecuted at all material costs. But the decision in Porrit is very clear to say that the adversarial system of South Africa makes a prosecutor to be passionate about the work that he actually does. So you don't find anything untoward by a prosecutor seeking to make sure that he secures a prosecution. And this matter has been 20 years in the works to do so. Nobody will be surprised that the prosecutor has become well-orientated with the matter and well-vested with the matter. So besides showing the fact that he cried on the matter and is passionate about it, the question of his independence and being compliant with the NPA Act is very important, and I think that is what they failed to demonstrate.
Because we heard from Advocate Thabani Masuku going in on that exactly, saying that the prosecutor ought to be trusted and that Advocate Billy Downer was emotional about the case. I mean, we are yet to hear from his side, right, in terms of the arguments, because we've mainly heard from the side of the former president so far today, but how to convince the court that he's emotional about the case because he's going after the former president and not because he's merely frustrated or wants to secure a prosecution and merely doing his job.
Yes, there's a distinction in the test when you are seeking a recusal of a judicial officer and a prosecutor, and this one will be a precedent-setting case, because a clear distinction must be made. And I had in the morning Advocate Mpofu arguing that there's no distinction, and then the court must not apply any distinctions whatsoever, and it must be the same. But as I've stated, that the principles are very clear that wanting to win a case at all costs is not a sin. And then this is what the prosecutor has been seen in this matter, being passionate about the matter. But now we are being referred to the statements that he has said, the spy tapes, the circumstances that he has said, the leaking of the medical evidence, which already we know that the court has ruled and said that there's no substance. But what is key and which is important to do is that there's a case pending against him to actually prosecute him, and they're now saying that he can't be the accused in another matter that is pending and then still, prosecute, the former president. So we can all wait with abated breath until 2030, until the real trial can really start happening.
You anticipate that's how long we're in it for?
Yeah, it's going to take longer, you can see, because, after this, if they are not successful, they can still appeal to the Supreme Court of Appeal. And then if not successful at the Supreme Court of Appeal, you can still go to the Constitutional Court. So by the nature of the history of this matter, we cannot promise that the trial is going to start next month. Obviously, that is not going to happen.
Legally and also perceptions-wise, how should we read that, right? Because you've got some sectors of the population believing, well, these are delay tactics. But the law allows for this, no?
Yeah, you're quite correct. Listen, there was an argument which was being put forward by the former president's legal team, which has some substance in it, saying that the Supreme Court of Appeal has said, that's the pot calling the kettle black. You cannot say that I'm the only one that was delaying. You were part in these proceedings also. You were also asking for the postponement because of the technicality of the matter and its own nature. That is why we have the delays. And another one will be saying, I want my rights to be protected. The NPA also will be saying that my prosecutor rights to actually prosecute must be executed. So that's why they're saying that it's a blame game for both parties. Not only one side is actually prolonging the matter, because the NPA is saying, this matter is being prolonged so that we don't get to the trial and get to the bottom of the matter. But what we heard is that both parties are equally guilty.
Advocate Romeo Nthambeleni essentially saying we need to buckle up. We're in it for the long haul where this case at least is concerned. Thank you very much for your indulgence and your patience with us this afternoon. Advocate Romeo Nthambeleni helping us make sense of the legal matter before the High Court in Pietermaritzburg.